Good morning. Welcome back. We're still watching Daybreak on this 10th day of February 2025. And in studio I have Dr. Eden Kenan, Member of Parliament for Eldas constituency from Wajir County. Good morning, Mheshimiwa.
Good morning.
I haven't seen you this year.
A lot of things.
Yeah.
Happy New Year.
Happy New Year to you.
Let it go.
Indeed. Mheshimiwa Njeri Maina from Kirinyaga County. Similarly, I haven't seen you this year. How have you been?
I've been good, you know, and the year is still new, so I think we are all trying to see how it goes.
40 days in, 41 days actually. Mheshimiwa David Ocheng, good morning. Welcome back.
Morning, Sam. How are you?
I am well.
Great.
We have so much to talk about. In the papers this morning, you're seeing the front page of the Daily Nation is a tribute to His Highness the Aga Khan, who was buried in Egypt. Of course, after passing on the 4th of February, you'll see different images on pages 2, 3, and 4, as well as 5, and paying a tribute to the man who was quite instrumental for the Ismaili community since the year about 1959 or thereabout. On the front page of the Standard, you'll see unpresidential Ruto. President William Ruto's sharp tongue is causing ripples across the country. From branding critics stupid to invoking evil spirits, his rhetoric is drawing backlash from clergy, lawyers, and political analysts. Once seen as a pious leader, his unfiltered remarks now raise questions about leadership, tolerance, and statesmanship. And of course, he just concluded a tour of the Eastern region on Friday. We'll be talking about that later on, and also how that impacts on what is becoming the 2027 political fever. But first, I want us to focus on a story that is on page 7 of the Daily Nation. How court ruling affects a Ruto agenda in the House. The National Assembly resumes business tomorrow after a break. Of course, the Christmas recess. There will be several changes unless the Speaker gets orders at the Court of Appeal. Lawyer Kanjama observes, and you will recall that sometime last week we saw the ruling of the High Court indicating that Speaker Moses Wetangula violated the Constitution in declaring Kenya Kwanza as the majority party. Just to give you context, is that at the time he argued that several parties had left the Azimio group and joined Kenya Kwanza Alliance, and therefore giving Kenya Kwanza a majority of 171, if I'm not mistaken, and 179 rather, up from 165, and Azimio's numbers had gone down from 171 MPs to 157. The court said that the Speaker ignored communication from the Registrar of Political Parties and insinuated that the Registrar had not disclosed the developments of what had happened, and therefore based his decision on that. The court found he had no legal basis to make such a decision. Mheshimiwa Ocheng, let me begin with you. What impact does this bring? Because your party is actually one of those that the Speaker used in deciding that Kenya Kwanza was the majority party.
Yeah, of course, this has, in opinion, serious implications, legally. When I was here to discuss this when this was happening, I told you that some of these are basically political questions. As to whether it's a majority or minority in Parliament, for me, it's a political question, not a legal question. And I've read the judgment twice now, fully, to understand the import of the same. And I can tell you for sure that the arguments there for me are quite shallow. Yeah, I disagree with the judges completely. Yeah, there's, if you read it and read it again, I would have expected something more from our judges in terms of setting what I would call the basic principles on how this should be dealt with in the future. But look, so 2022, we're in Parliament, there's jostling for power and all that. Some of us are from elections. And for example, our party, MDG, was in Azimio. But when the campaigns were happening, other Azimio principals came to campaign against us in those elections. And so after you win the election, how do you then go back and be a part of a party that was campaigning against? I mean, there were so many issues that happened around that time, in my opinion. But onto what the judges talk about, because that is actually the main issue. They don't expound more than that. They just say that because the registrar had said had given a letter saying that the following parties, as in Azimio, didn't take into account the facts of the day that, for example, the party called PAA had left Azimio before elections. MCCP had left before elections. So many parties had left before elections. Okay, just after signing, and then they left before the elections happened. These are facts that I believe that a court, well-guided, would have considered in reaching this decision. And so I believe that much as...
So how do you leave a coalition?
By doing a notice as required by law, by going to the relevant organs of the coalition required. But the question that you asked is a very instrumental one. By the time we went to the elections, Azimio had no structures. By the time we left elections, it had not set up those structures. That, for example, when MDG was applying to get out of Azimio, there was no even an email address to send a letter to. You went to the offices, somewhere in Lavington, they were closed. You couldn't serve anybody because there were no structures. There were no offices. There was every reason and every effort taken to ensure that nobody is able to reach the Azimio principles, as it were. There are members of Azimio party, and I think these are in the court records, as it were, that you are being told, if you ask, where do we go, you're told, go to UNET. If there was no office, there's no way you'll be told, now go to this institution, go to this office and serve your letter. And so there were so many frustrations around that time, some even emotional, that go with elections.
So looking back, what decision should Speaker Wetangula have arrived at?
I believe the decision he arrived at was the right decision. Because the parties that are mentioned, the 14 parties that are mentioned, Sam, did not walk into Kenya Kwanza at night and declare that, and say that now we have... No, these are parties that declared publicly that we've left Azimio and joined Kenya Kwanza. Okay. The party I belong to, for example, signed a post-election agreement with Kenya Kwanza.
Yep.
And these documents were tabled on the floor of the House.
But you didn't... how are you to leave Azimio based on the constitution that, or the agreements that you signed?
The argument put forth by the Speaker, which I agree with completely, was the freedom of association. Yeah. The freedom of the party and the individuals who belong to the party to associate with whomever they want.
All right.
And I believe that much as political maturity requires that certain rules be followed, one party cannot decide not to ignore those rules. Another party be required to follow those rules completely.
I've asked you a question.
Yes, sir.
How did you leave Azimio?
We sat as a party, in a party executive committee, made a decision to leave Azimio, wrote to the chair of political parties with the decision of the NEC, as required by law, wrote the same letter to the Azimio Secretariat. And at that point is where we could now not find where to send these letters to.
By the time the Speaker was making that decision, you had already written to the registrar?
Yes, much earlier, actually 4 weeks before.
And you had complied with the guidelines on how you leave the coalition?
I've just mentioned to you, Sam, that it was not possible at that time because Azimio...
So, as a question of fact, had you complied with the regulations on how you leave?
There was no means of doing so, and that's the point I'm trying to make. There was no means of...
So can you then fault the judges in deciding that the registrar presented the information as she knew it to be, and there was no point of the Speaker questioning?
I disagree completely, because at least the registrar would have mentioned to the Speaker that she has received communication from the MDG party about their exiting Azimio and this appending matter before the Azimio structure.
If it's pending, is it done?
I mean, you know, there's a principle in law that equity, consider that ought to be done to have been done. In this situation, Sam, if a party says, we no longer want to get involved in this arrangement, why would someone insist on it? Okay, all right, I'll get back to you. Mheshimiwa Njeri, of course, you were the beneficiary at the time. I don't know whether you still feel so. But yes, it is Kenya Kwanza that gained the numbers. Do you think, legally, was this a fair decision?
You know, it's quite interesting, Sam. I'm waiting to see whether Junet Mohammed will be claiming Kimani Ichung'wah's seat. So we are going to have quite an interesting time tomorrow when we resume Parliament. What I want to say is that I think we have a knack for not following the due process. It seems to be a Kenyan thing, and it seems to have been adopted by the August House, because we can see right now, even as we speak, that Azimio, as we know it, as fashioned, has been decimated. ODM members of parliament have been given cabinet positions in government, and they still claim that that ODM is not part of government. So I think we like to bury our heads in the sand, and we like to take the shorter route.
Yep.
And with all due respect to my colleague here, and I believe that at the time, the decision that Speaker Moses Wetangula made, I think his hands were tied, Sam, because even in a marriage, you cannot force two partners to stay together. Even when the facts are that it is one of the partners who has breached the agreement or the marriage setup. Yep. So we all know that right now WDM is purportedly out of Azimio. We have Kingi, who is the Senate Speaker. Chap, we have the CS. And really, let us say that there's a legal quagmire. We are caught up in a legal quagmire because due process was actually not followed. So I cannot fault the judges for arriving at this decision. But it is a situation that we were all caught up in, because even as we speak, those orders or directions in the legal... in the legalese of it would be overtaken by events, because Azimio, as we know it, has been decimated. And like I've said, I'm waiting to see whether Junet Mohammed will be crossing over to claim Kimani Ichung'wah's seat.
As you say that his hands were tied. Tied by who?
Tied by the actions that parties like MDG and PA and Maendeleo Chap took. Because the facts on the table that Speaker Moses Wetangula was relying on is that these parties had even communicated via letters, because those letters, I believe, were read on the floor of the House. They had communicated their indication to leave, but then the legal provisions and the necessary procedures were not followed. So we really cannot fully fault Moses Wetangula. We cannot fault the judges for arriving at this decision. It is just that we were caught up in a quagmire.
But how do you request for information from a constitutional institution, which is, in this case, the Office of the Registrar of Political Parties? You receive information, then you argue it out, and you rely on information from politicians.
No, I think what the MDG party leader has even tried to explain is that the marriage was already done before the elections, but then the procedure and the process that was supposed to be duly followed was not followed. And like I've said, you really cannot force the practicality of it. You cannot force coalitions or people to stay together. I know even right now that WDM has not exited legally from Azimio coalition, but we see them saying that they have exited. I know that Martha Karua, NARC Kenya, has exited.
Right.
Formally. But then let us also understand, like I've said, that there's a certain manner in which we're used to doing things by not following the due process.
Right. And joining us now is Jane Kagiri from Laikipia. Good morning, Mheshimiwa.
Good morning.
Great. And Dr. Eden Kenan, so how should the Speaker of the House determine what a majority party is? Because if you have to rely on the current setup of the House and what has changed over time, it would give you a different impression. So do you determine after the general election, or is it a moving target that as people's wishes and allegiances change, you can also change who the majority is?
I think there are two things that we need to look at. Politics, first of all, is so dynamic. And by definition, it is the art of the possible. This ruling has come almost 3 years, 2.5 years, since the last general election. And I entirely agree. I've also gone through it. I entirely agree with what Honorable Ocheng has just said. A court ruling must be predictable, must be practical.
What do you mean predictable?
Predictable meaning it must be something that is cogent, it must be something that can give you an understanding of how we are going to interpret it. And that's exactly what he was trying to say. You see, a lot of things have changed. On the face of it, in our books, I'm the national deputy chairman of Azimio. Obranya is supposed to be the national chairman. So many things have changed. As he has raised, I do not know where the offices of Azimio are. We have never met since the election. Okay?
Why haven't you met?
I don't know. The owners have decided that there shall be no meeting, and I don't know who the owners are. You see, and I want you to understand this, and I also want you to be very realistic even in the line of question that you take.
Just
take this. The numbers were determined based on the realignment and alignment that took place on or before the election of the speaker and the formation, the decision to decide which group formed the majority or minority actually was. And then I entirely associate myself with what the decision reached at that particular time by the Honorable.
That's what I'm asking. Should you determine, I mean, I still have, you're still on the floor. Should you determine the majority and the minority based on the allegiances of the politicians, or is it based on the vote expressed by the members that form the electoral register who express themselves in an election?
And I think it's also fair that when you ask a question, you also give me an opportunity to respond to the same. But I was saying,
the question,
the issue, first of all, at hand right now is the judgment. That judgment attempts to micromanage Parliament.
How so?
Attempts to deal with political issues that ideally be left for politicians.
But it is
let me finish.
Your party has made that went to court.
Let me finish. Even after going to, you know, the court does not operate in a vacuum. The court operates within the realm of the Kenyan society. The Kenyan society is not a moving target. The Kenyan society exists. Since that petition was lodged, Mother Karua's party, Mother Karua was supposed to be the deputy, I mean, call it the running mate of the Azimio candidate. She left. Have you had any...
No. This matter was taken to court in October 2022.
I want to give you...
Before all these things happened.
I want to help you understand why this is inconsistent. This ruling does not explain anything. And I will say that it's an attempt through the back door to manage political activities. You see, now Kenya left. Mother Karua was the running mate of Raila. No Azimio meeting was held to confirm or deny the same. Jubilee left. They left. UDM left. So which is this Azimio you are talking about right now? It doesn't exist. If it exists, it exists in the utopian world. That being the case, in August, immediately after the August 2022 general election, so many things happened. The right to association, I think he has rightly put, and that is a fundamental constitutional issue. The right to associate. You cannot be forced to a marriage that you do not want. Parties realigned. But there was the issue of the 3-month notice. Okay?
Yep.
There's the issue. That was again subject to the legal interpretation. I think that's one of the issues that the court has alluded to. That being the case, even after 3 months, 3 months from August 2022 will have been sometimes in 1st January 2023. The court should have been alive to this fact that from that time until the day when they have issued the ruling, so many things must have happened. And some of these things were in public.
But was there any evidence that was tabled to that effect?
Where the judges don't live in Kenya?
None.
The lawyers have also expressed this. The lawyers on record have expressed this. And I will tell you since there's what has happened. Now Kenya left. My friend's party left. UDM left. Jubilee left. Jubilee now is an independent parliamentary party, the third. So those things have changed. So this ruling has no effect in law. Has no effect. The majority leader still remains the Honorable.
So when did Jubilee leave Azimio?
We left. We gave the notices, but there was no Azimio to sanction. We left a long time ago through a NEC resolution, through a BG resolution. We sent the same to the Speaker.
Which NEC?
The NEC of Jubilee.
Chaired by who?
Chaired by the Chairman Nzuya.
But you know there has been contest about...
Agreed. That was done after. It was the issue of who is the secretary. But that decision was done by the majority, and that has not been questioned, by the way.
Who was the Secretary General signing off?
That is a different... We have... that's one individual. It's the decision of the parties made by the NEC. And by the way, for information, we had 25 out of 28 NEC members.
I'm saying there has been contest about decisions made by that NEC.
It didn't affect... Fortunately, it didn't affect the issue of our exit from Jubilee. It's only Kioni who has remained, from our exit from Azimio, it's only Kioni who has remained in Azimio and Jubilee. The truth of the matter is, out of 34 members, 32 have exited, okay? We have notified the Speaker. We have been recognized as an independent parliamentary party, and we have a whip, just like any other
That's
party.
what I'm saying.
And therefore, right now, we have 3 parliamentary parties. Three. Okay? Jubilee is one of them. So that being the case, where does this ruling take us? It takes us nowhere.
The reason why this is important, Mheshimiwa Kenan, all those things you're referring to are consequences of the decision by the Speaker in determining...
And the court should have been alive to these realities.
But the court is reflecting on the matter before them and saying...
One abstract petition that was given in...
Just hold on, Mheshimiwa Kenan. The court is reflecting on the decision made by the Speaker and saying it was unconstitutional. So everything else should ideally be unconstitutional, isn't it?
You see, that petition was filed at that particular time.
Yeah.
There must have been some allegations, generalized allegations. The court took over 2.5 years to adjudicate on the same. Since then, so many things have happened. The court has been notified of these changes.
But that do not...
The court decided to stick... The court decided to stick to the old petition. And therefore, that's why even if today you wanted to interpret this, you bring it to Parliament and you want to pursue the interpretation of Article 108, it stands nowhere.
Okay. All right. Mheshimiwa Kagiri, what do you make of this? Because like he says, and he hasn't answered my question, the question was, do you determine the majority based on the vote taken by Kenyans or based on the allegiances of members of Parliament once they assume their seats in the House?
Thank you, Sam. Sam, let me first start by stating I'm not a lawyer, so I'll just try to answer from my layman's background. Number one, I looked at the ruling and I saw it was 70 pages. It had 508 paragraphs. I realized there were 35 prayers, some which included Azimio areas should not pay taxes. Others included that there was the issue of the finance bill. But I also realized out of all the many prayers, the judges only honored 3 or granted only 3 of their prayers. And one of them was to state that the majority party, the majority side was determined by Kenyans as at 9th of August 2022. Just as my colleagues have said, and again I say it's from a layman's view background. Number one is that you cannot force people to be where they don't want to be, or parties to be where they don't want to be. So for me, I would want to agree that a decision was made by the courts, a decision which I personally disagree with, and I'm hoping our side is going to demonstrate whatever reasons they have at the appeal stage. But that said, I would still think the ruling is overtaken by events, because just as my colleagues have stated, many of these parties have left. And I remember most of them raised issues of coercion, being under duress for them to have remained in Azimio at the time. But coming into Parliament, and that is after 9th August, they had the right to make a decision. They had a new president in place, they had a new leader, and they had a choice to make on what side they wanted to be on. And I believe, as it stands now...
So you make a decision based on who is in State House?
No, I'm saying these parties made it very clear in the public and stated that they had been coerced to be in the coalitions that they were in. Now that they had the freedom to choose, because maybe whoever was coercing them was no longer in power, that is why they made the possibility to move to whichever side they wanted.
Mheshimiwa, you were coerced to be in Azimio?
I didn't say Honorable Ocheng, I said...
He's a party leader.
There are some of the parties that stated that.
He's a party leader. Yeah. Were you coerced?
Yeah.
So tell me here, because she says she's not a lawyer, you are. How do you determine the majority? Is it based on the wishes of the politicians? In which case, then that would be a moving target, including today you can change the majority? Or what should happen?
I want to try to convince you, Sam, that this issue you're asking is a political question. It isn't a legal question, in my opinion. For this reason, see, Kenyan constitution is borrowed from so many constitutions, American, Canadian, you know, even our neighbor South Africa, down here. But the way Parliament works is that most of the time, courts allow Parliament to run its own affairs. For example, if you look at what the law says that the majority will decide that the party or the coalition of parties that has more members of Parliament. Now, for me, the issue of whether a party has more members or not is a factual issue.
Yeah.
It isn't a legal issue. It's a factual issue. And how do you determine these facts? By one, what the registrar did. He asked, how many collections have you received? What are the memberships like? Number two is, what do the parties, political parties themselves say? Because, and the question asked about members voted. Political parties have organs that make decisions. Like the MDG party has a neck that processes these kind of decisions. Jubilee party has a neck, and probably the delegates conference that makes some of these decisions. If a party has decided after elections, for example, that this is the way you want to go, and the party avails itself to the available legal strictures that should be followed, but those strictures are not allowed to operate. They're not supposed, a party is supposed to do. To be held hostage through agreements that are not being followed through. So I personally believe that the issue of whether Parliament, the majority or minorities, were decided rightfully, for me, it's a political question which the courts should have steered away from.
At that time, let me ask you this. Was it possible to, based on the facts presented by the registrar of political parties, determine that Azimio is the majority, but 3 or 4 months later, down the line, change status and say facts have changed? Is it a possibility?
It was, and I've told you, and I want to try to put this clear to you, that, for example, the letter for the MDG party was delivered by me personally to the office of Register of Political Parties before Parliament was even called. I personally went to the Register of Political Parties on Wayaki Way, personally. I personally drove to what used to be the Azimio offices in Lavington, personally in my car, and I was told, this office, there's nobody to receive your letter here. I was given an email address where you could send this to. Mm-hmm. So if processes that are required to be followed are frustrated, what do you do? Because these are not things I'm telling you I send somebody to. After our NEC meetings, I personally drove to the office of Register of Political Parties and filed the notices as required, filed the resolution as required, and the letters were stamped, and he advised me, go to these offices. I went there personally. These offices.
Did you table that evidence?
Yes, I did.
In court?
Yes, not in court. I tabled in the parliament. Tabled the same in court. I did. The MPG was anticipated part in the court process, and we tabled this in court.
Yeah.
And so, Sam, I don't want this, for me, to be an issue, but it depends on what the judges say. This should be left to Parliament for Parliament to decide, because that's how most parliaments work. Number two, the reason that is important to me is, now, judges, as a principle of law, when making a decision, judges should always look at the practicability of their decisions being executed, being implemented. This decision that was made on Friday, how is it possible to implement it now? Because if you make a decision that is rendered negatory because of circumstances of the situation, how are the judges going to ensure that the decision made on Friday is executed? How is it possible?
Okay. We'll come back to this. Take a short break here on Daybreak. Citizen TV Kenya Tsamgituku. That's the hashtag that you can use to write to us on X, and also you can write to us on Facebook. We'll be reading some of your feedback after the break. Stay tuned.